Hi, I'm Brice Zoecklein. I get questions from a lot of our clients about, well, hey, what is probate? Probate is a court-supervised process for identifying assets of someone who passed away, paying their debts, and then ultimately distributing assets to the appropriate beneficiaries. In order to understand how that works, you need to first understand that some assets are subject to this process and some are not. The assets that are subject to the process are known as probate assets. The ones that are not are known as non-probate assets. And in fact, there's a push in modern estate planning to try and avoid probate altogether. So let's look at some examples of non-probate assets that are not subject to this proceeding. Well, number one, you got a transferable or payable on death account. So if you identify a specific beneficiary on your bank account, then when you pass away, that person will inherit the account directly, and the monies don't need to go through a probate, and importantly, they're not subject to probate creditors. This concept also applies to jointly owned property. The most common way to jointly own property in the state of Florida is from a married couple, and that's called a tenancy by the entirety. If you see on a deed John Doe and Jane Doe as husband and wife, that's a tenancy by the entirety, and the surviving spouse will automatically acquire full ownership interest in the property, and it doesn't have to go through a probate. Non-married individuals can also hold property in a joint way and with the survivorship, and that's called a joint tenancy with the right of survivorship. You can also hold bank accounts in Florida jointly. Married couples do that all the time, but other folks can hold property jointly too. When a joint owner of a bank account passes away, for most Florida bank accounts, the survivor obtains all of the funds in the account without having to go through probate. Another great example is life insurance. A life insurance company has an obligation to pay the identified beneficiary without it going through probate. So you can oftentimes get life insurance benefits without the necessity of a probate. And finally, if you've gone to the trouble or if someone's gone to the trouble of creating a trust, those assets pass automatically without having to go through a probate proceeding. That's very important because passing assets outside of the probate allows you to avoid paying creditor claims in some circumstances. So then, what are the probate assets? Well, the opposite of what we talked about. Assets without a specific beneficiary designation. Here's some examples. John Doe holds property in his individual name, bank accounts in an individual name, cars, trucks, boats, business assets, and other personal property, the things that don't have a specific beneficiary designation. So why do we even have a probate? Well, it does a few key important things. Number one, when someone passes away, sometimes there's a dispute as to who are the appropriate heirs. Also, sometimes it may come as a surprise that there's a last will and testament. So the holder of a last will and testament has an obligation to provide that to the clerk of court. So generally, a dispute among the heirs. Number two, it provides a mechanism for creditor claims against the deceased to be paid or litigated if they are disputed. So if the deceased had a bill, then the creditor files what's called a statement of claim in the case, and there's a mechanism for getting that paid. Finally, the probate court process and the authority from the court is what allows for the legal transfer of assets when someone passes away. So instead of a deed, court orders transfer title, and personal representatives and executors have the authority to transfer other assets to the appropriate beneficiaries through a court proceeding. So you might be wondering, well, how does a last will and testament fit into this proceeding? Well, what a last will and testament does is allow you to identify who your beneficiaries are going to be, and it also allows you to nominate an executor or what Florida calls a personal representative. That document to be valid in the state of Florida requires it to be signed by the testator, which is just the person making the document, and also witnessed by two witnesses. And the purpose of that is to get an allocation of assets that is different from the default rules. If you don't write a last will and testament, your assets are still subject to probate. They are just distributed pursuant to the rules of intestate succession. In general, that is a distribution to your spouse and children, if any. If the deceased person had no spouse or children, then just generally know that it's distributed to their collateral kindred, which just means other more distant family members. So what actually happens in a probate? Well, there's different procedures, but generally what occurs is there's an identification of the assets for the court, there's a notice provision to known heirs and beneficiaries, and a notice provision to known creditors. There is then a distribution of assets, all supervised by a judge. This is accomplished either through what's called a summary administration or a formal administration. But in both cases, the process is there to ensure that the right individuals receive assets and the creditors have an opportunity to participate in the proceeding. If you'd like any additional information, we have tons of great resources regarding probate in Florida on our website, or simply give us a call.